Yes, Mr. Akins.
My lords, my lady, I was dealing with ground one and looking at the law.
Could you speak up a bit? I'm sorry.
Sorry?
Could you speak up a bit?
Of course, my lord, of course, sorry. Yes, before the shorter German, I was dealing with ground one
Yes.
and the law that's relevant to that. And the next question I want to address is a question of law. Is a finding of unfair advantage itself always sufficient for a finding of damage in a claim for passing on? And in my submission, the clear answer to that is no. Firstly, there's no authority for that proposition, maybe what my learned friend is looking for in this case. And second, such an answer would be inconsistent with the authorities on unfair advantage. And for that, I rely on this court's decision in the Argos case, which cites the Court of Justice in L'Oréal and Beaulieu. And that is in the Authorities Bundle B, tab 12. It's the section headed discussion of unfair advantage that I rely on. It starts on page 387.
387.
387, paragraph 102. This is Lord Justice Floyd discussing the law on unfair advantage. And there are two aspects of this analysis that I rely on in particular. The first is paragraph 102, where His Lordship talks about the different forms of injury, in inverted commas, that are alternatives for a finding of infringement under section 10.3. Those being unfair advantage, number one, number two, detriment to distinctive character, and number three, detriment to repute. And he says rightly, unfair advantage is categorised as a form of injury, but that's in a manner that may seem odd to English lawyers, because it's not injury to the trademark or the claimant. It's an advantage to the defendant. And he says that unfair advantage does not require that there be a likelihood of confusion or a likelihood of detriment to the distinctive character or the repute of the mark, or generally to its proprietor. So you can have unfair advantage without any detriment, as we have in this case.
So where are you reading from?
Sorry, that's 102.
102.
And the first sentence of 102.
Yes.
And then the next section I rely on is 107, on page 389, where the Lord Justice Floyd talks about the requirement for a change in economic behaviour. And it was established by the Court of Justice before this case that a change in the economic behaviour of the average consumer of the claimant's goods or services was necessary for a finding of detriment to distinctive character. And the question in this case was whether that was also necessary for a finding of unfair advantage. He held that it wasn't. What could be sufficient is a finding of a change in economic behaviour of the defendant's customers, or customers of the defendant's goods and services.
Yes.
That's in the so just above D in the left on the left hand. By no means follows that there is a requirement for evidence for the change in the economic behaviour of consumers of the trademark proprietor's goods or services in order to establish unfair advantage. My judgment, it should be sufficient to show a change in economic behaviour of customers for the defendant's goods or services. So there can be unfair advantage but no detriment if the only change in economic behaviour established is on the part of the defendant's customers, not the claimant's customers. And in my submission, there is no difference in meaning between detriment in this context and damage in the context of a passing off claim?
Well, it depends what you mean by damage, I suppose. I was looking at the One Step and Morris Gardner over the short adjournment, which is the most comprehensive Supreme Court judgment on the question of negotiating damages, as they're sometimes called. And essentially what the court says is that if A has a right to stop people doing something without his consent, and B does it without consent and without paying for it, then A suffers a loss, because what he's lost is the ability to control whatever it was that B shouldn't have been doing without A's consent.
My Lord, there's a procedural point that I take on that, and also a substantive point. So the procedural point is that it is not said by my learned friend that that's where the judge went wrong as an error of law. In this case, he was not equating this type of situation to that type of situation. So, in all honesty, I'm not prepared to deal with that.
Because his first head of loss was explicitly loss of licence from the defendants.
Right, well, but my answer to that is the one that was given before the short adjournment, which is that makes the requirement for damage entirely circular and rubs it out of existence altogether. But my second point in response to that is that there is a difference between establishing whether a remedy of damages is available to a claimant and establishing damage as an element of a cause of action. And so I put the one-step case in the former category, and this is obviously in the second category, so that's why that's not opposite to this case. So yes, my conclusion on the law is that detriment is synonymous with damage. So if there is no detriment, a finding of no detriment, that equates to a finding of no damage. And you can have unfair advantage without detriment and therefore without damage. So next, I need to go to the judgment and go directly to the key paragraph, which is 237, and that's part 8 of the core bundle, page 176. Because this is where it is said that the judge goes wrong. Now, first, it is a concise paragraph. It's a concise finding. It's a single paragraph finding, but that's understandable and justified for two reasons. First, it appears at the end of a long judgment in which the judge had already covered some of the necessary ground. And secondly, EasyGroup did not make any detailed submissions on damage. And for that, so their closing submissions on damage are just one paragraph. They're in the supplemental bundle, tab 11, page 143. And it's that single paragraph 160 at the bottom of that page. So their case was economic damage would flow from misrepresentations in the usual way as a result of confusion, direct and indirect. Further damage will be caused to the goodwill because if third parties such as the defendants are able to benefit from the Easy Family Mart reputation goodwill without a license, then the ability of the claimant to charge others for such licenses will be diminished. Key point there is that they did not establish that diminishment on the facts because there was no evidence of that. And that is where this case can be distinguished from the fine and country case, which I'll come on to, because in the fine and country case, it was established that the ability of the claimant to charge others for licenses had been diminished. There was evidence of that. So back to paragraph 237 of the judgment. In the first, this is the next ingredient which has to be considered. Absolutely right. Here, Mr. Edenborough's case fails, although I have found an intention to forge an otherwise absent connection. So there he's acknowledging his previous finding on intention and weighing it in the balance on this element. I do not consider that there is sufficient evidence of the likelihood of damage. And then he deals with, he makes two findings of fact that aren't challenged. No realistic suggestion of a diversion of trade, nor, in my view, is there any real likelihood of damage to the repute of those brands. He deals with the Trustpilot reviews. So those are unchallenged findings of fact. So therefore, my learned friend must focus on the last sentence. Mr. Edenborough relied on benefit to the defendants in being able to use signs 2 and 3 without a licence as giving rise to damage, because the ability of the claimant to charge others for a licence would be diminished. But I'm afraid I do not understand that logic. So, yes, my Lord Justice Lewison picked up on the use of the word logic there. He focuses on the logic, but he is not saying that that submission is precluded as a matter of law. In particular, he's not saying that if EasyGroup had produced evidence, as there was in Fine and Country, that the ability to license had been diminished, then he wouldn't consider it, because that's not relevant as a matter of law. In my submission, what he is saying is that it doesn't follow automatically. He can't join the dots between, first, the benefit of the defendants being able to use the signs in this case, secondly, the diminishing of the ability of the claimant to charge others for a licence, and thirdly, damage. So this is not saying, well, had that been, if that was sufficient as a matter of law, then I would have found that. It's not saying that.
Can I ask you this question? What the judge doesn't say is there's no evidence to support this, does it?
Well, but he does say earlier in the paragraph, I do not consider that there is sufficient evidence of the likelihood of damage. So he is making a finding that there's insufficient evidence in this paragraph, which is the only paragraph dealing with damage.
That's a good point. I'd see that, thank you. But when it comes to this particular point, all he says is he doesn't understand the logic, which seems, I mean, the use of the word logic rather suggests, does it not, that he thinks it can't follow.
It can't follow in this case. He can't join the dots in this case, and it can't follow automatically. That is my point. That is my submission. The diminishing of an ability to charge others for a licence does not follow automatically from the benefit conferred on the defendants in using signs 2 and 3. You have to go further than that. You have to establish that. And the defendants did not do that. Oh, sorry, the claimant did not do that in this case. And my learned friends have not pointed to any evidence that would establish that in this case. All they rely on for this ground of appeal are the findings in the context of unfair advantage. That is the scope of the appeal.
Yeah.
And so I need to go back to those. A learned friend tipped me to them, but I need to cover them because that's what they rely on. So those are in paragraphs 214 to 217. So starting on page 169 of the bundle. But my learned friend focused on 216 and 217. I think while I'm here, it's convenient to look at all of them because then I won't need to go back to them when we look at the respondent's notice arguments as well. So in 214, the judge is dealing with link. So the second condition for finding of a trademark infringement under section 10.3. And he concludes with the assistance of the additional matter that a link is likely, and that additional matter is that it is Mr. Burnside's intention. Specifically, and this is 4 lines down, I consider that he sought to create a link with the EasyJet family in the mind of the average consumer when he chose to bring his sign closer to the Easy brand sign. As I pointed out, he was giving to making allusions to other products when it suited him, and that, in case my lords, my lady haven't picked up, was a piece of advertising material in which the Easy Live auction had used a mock-up of a compare the market or comparison of different auction services. He accepted he was aware of EasyJet at the time and knew it was a big entity, which must mean he was aware of the EasyJet mark. He probably intended, in a manner he would describe as cheeky, his word to characterise his other references to branding. That's the compare the market use. To call to mind the EasyJet branding, to use the phrase appearing in the authorities. That being his intention, it hardly lies in his mouth to say it was completely unsuccessful. So that's the finding of intention to create a link. 2145 says that applies to signs 2 and 3, but not sign 4. And then 216, the unfair advantage condition is fulfilled for the same reasons as we've seen in 214. So Mr. Burnside intended the allusion to the mark because he thought it would bring some, albeit limited and unquantifiable benefit to his company's business without paying for it. So, and then his company was riding on the coattails of the EasyJet mark and the members of its family. That is taking unfair advantage. It's hard to see why it would not be unless it was so hopeless as to be ineffective, which it wasn't. So just pausing there, and in answer to pick up on a point my Lord, or a suggestion my Lord Justice Lewison made before the short adjournment, that is not a finding that the average consumer would perceive Easy Live Auction to be a member of the Easy family, would be a licensee of the EasyGroup. It doesn't go that far. And then 217 deals with the change in economic behaviour. And he finds that there was a change in economic behaviour, but only on the defendants' customers, not the claimant's customers. And in particular, one section of the defendants' customers, the retail bidding consumer, and probably not the auctioneer, so there are 2 categories. That is it. That is all that EasyGroup can and does rely on as being sufficient for finding of damage. In my submission, that clearly falls short. Particularly, there's no finding of...
Sorry, can I just ask you again about 216, because you said it wasn't a finding about the family, but what do you say about the middle sentence where he says his company was riding on the coattails of the EasyJet mark and the members of its family? So at that point, he does seem to be having regard to the family, doesn't he?
He has regard to the family, but he's not finding that the bidding customer, when they see this stylisation of Easy Live Auction, assumes that Easy Live Auction is a member of the family. He's riding on the coattails because there's an allusion, there's a calling to mind, and that has...
So your point is about the nature of the misrepresentation.
Well, I think misrepresentation I would shy away from using, because it's not a
Well, at
misrepresentation.
this stage, he's talking about unfair advantage, to be
Yes,
sure.
exactly. Yeah, yeah. The nature of the link and the unfair advantage. It's a calling to mind, but it's not an assumption that there is an economic connection. It's not an assumption that there's a licensee. And that's perfectly, that is a perfectly legitimate finding of unfair advantage. It's a calling to mind. You are reminded of it, but there's no confusion, and there's no assumption that there's the economic connection and it's a licensee. He finds that produces a benefit for the defendants' businesses, because the customers will look on it with more favour or less disfavour. But that's not because they think it's a member of the family. It's just because it's calling to mind, it's reminding them of it. So there is no finding here of any damage caused to EasyGroup's goodwill or reputation. There's no finding of any change in economic behaviour on the part of EasyGroup's customers or its licensees' customers. And in particular, there's no finding of any diminishing of EasyGroup's ability to charge others for a licence, which is what the case was on damage and passing off. So the finding of no damage was entirely consistent with the finding of unfair advantage, and the ground of appeal fails purely on that basis. But in my submission, it gets worse for EasyGroup, because in 218, the judge considers the allegations of detriment to the distinctive character or repute of EasyGroup's trademarks, and he rejects those allegations. Picking up in the second sentence of 218, I do not consider that there was any real detriment to the repute or distinctive character of the marks. Nothing happened which would be likely to have worked to the detriment of the distinctive character of the EasyJet mark or the other marks, and there was no evidence that it occurred. Then he deals with repute and the Trustpilot findings.
Well, I understand your points you've made up till now, but I don't understand the relevance of 218, given the way the case is put by Mr. Easygrope. He focuses on misappropriation of goodwill. He's not arguing that there's detriment to repute or distinctive character of the trademarks. It's all about using someone else's property without paying for it. So how is 218 relevant to that argument?
Well, if as a result of, on my learned friend's case, there has been a misappropriation of goodwill, but there has been no detriment to the distinctive character of these marks, then in my submission the damage element is not made out. Otherwise it means nothing.
That highlights, I think, a fundamental issue of law between the two of you, because what this discussion has revealed is that you are fundamentally disputing the legal proposition upon which Mr. Edinburgh bases his case, because you say misappropriation of goodwill without more is not actionable, because you say there's no damage and it's therefore not passing off.
Well, I need to be careful in pushing back on the misappropriation of goodwill, because what has been found here is that they have used the signs in a way that has created an unfair advantage. And what I am saying is that that is not sufficient. That does not result.
So does it come to this then, that you are saying that use of a sign in a manner which does no more than call to mind the claimant's mark to which goodwill attaches does not equal misappropriation?
Yes.
Is that what you're saying?
Yes.
If there had been misappropriation, would you accept that that misappropriation of itself causes a loss?
I'm struggling with the word misappropriation, I think, if it means something more than what I've just conceded. So if there is misappropriation, but no detriment to the distinctive character of the mark, then there is no damage.
Right.
You could say, well, if there's no detriment to the distinctive character, there's no misappropriation. And I think I would support that as a proposition. But what is clear is that there is a finding here, unchallenged, of no detriment to distinctive character.
Well, to be sure, and you're entitled to rely upon that, and I understand what you say about it, but I think what I'm struggling with at the moment is what you're saying about 216. And it might be worth going back to it, because the finding is twofold. Firstly, there's an intention to create an illusion to the mark, and secondly, for the purpose of bringing benefit to the defendant's business without paying for it. Now, that's what I understand Mr. Easygroup to be particularly relying upon, and that's what he characterises as a finding of misappropriation of goodwill. Now, I understand that you're hesitant about committing yourself on terminology, and I respect that, but I'm still not quite clear as to what your answer is on the question of law. And just use to avoid terminology that you're uncomfortable with. Let's put it in terms closer to the way the judge puts it. Benefit to the defendant's business without paying for it.
That, in my submission, is not sufficient as a matter of law for damage to Arsenal. And if it was, then the damage element would mean nothing, and we should just get rid of it.
So as I understand it, you benefit to the defendant's business is not enough, you say. You say, as I understand it, you need some form of damage to the claimant that goes, if you like, beyond what might be described as a form of damage in the sense that the defendant has got a benefit.
Yes.
You say you need to point to something else.
Yes, that's absolutely right, my lady. And in particular, in this case, the claimant need to show that their ability to charge licensees money for using the marks, their portfolio of marks, was diminished. That was their case on damage.
So you took us to the closing submissions, and as I recall, it made that point, and it made a point about confusion.
Yeah. So either confusion, if there's confusion, there's going to be diversion of trade. It's direct finding that there's
Okay,
not.
well, this might be a convenient moment to ask you about Mr. Edinburgh's second head of damage, because your fundamental answer to his first head is you say it's not enough as a matter of law, and we've been over that. But then, so far as the second head is concerned, I take your point, you say there's no evidence. But Mr. Edinburgh's case is it's a natural inference, because if the defendant can do this without paying for it, then anybody else can.
That would be a natural inference for any licensor. And again, that's how I distinguish this case from Fine and Country, which I think is probably a good time to take you to that one. So that's in the Authorities Bundle A, tab 6. And paragraph 77 is the key paragraph on this point. 76, sorry, 76. So here, the finding of damage was challenged on appeal. And so that's why my Lord Justice Lewison deals with it here in paragraph 76. The last complaint is that the judge was wrong to find that damage had been caused. or that real damage was likely in the future. In fact, the judge found that no measurable damage had yet been caused. His concern was for the future. And on the basis of Mr. Linley's evidence, that Mr. Linley had a well-founded perception that fines activities were likely to lead to the erosion or dilution of the Fine and Country brand and was thus a real threat to his business. Platts Mills criticised this finding as mere speculation, pointed out that although Fine had been operating for 3 years, no actual damage yet being caused, then the judge recorded evidence that Fine is beginning to attract contacts and potential licensees away from Fine and Country. A particular example being the applicant for a licence in Chelsea, who apparently withdrew because of his perception based on his experience in Surrey of brand confusion. That is a finding of primary fact. So that is the difference between that case and this case. There is no equivalent evidence in this case. My learned friend has not even pointed to any witness evidence saying that there was a fear that there would be a diminishing of the ability to track licence fees in the future. So in my submission, it is simply not open to this court to make an inference to that effect in circumstances where it's not an irresistible inference, and in other cases have required actual evidence to establish that.
To what extent is it relevant? I think you referred to it before, that the findings here relate to signs 2 and 3, which are out of use.
It's relevant because the Sorry, excuse me.
This is future looking. The
Yes,
passage
exactly.
you've just taken.
Exactly. So it's the misrepresentations finished 3.5 years in this case before the trial. So if there had in fact been any damage caused, then evidence would have come to light by the time of trial, and there was none. So we do say that that is very important, my lady, in this case, that the misrepresentations were only in relation to signs 2 and 3. Sorry, just while I'm on Fine and Country, there is also if I can take you to paragraph 27 as well, just for completeness.
Paragraph 27.
27, yes. So this is where my lord is describing the judge's decision and describes the judge's finding. And it's the last sentence. The likely damage that he perceived was the erosion or dilution of the Fine and Country brand. So that, again, is a finding in that case, upheld, which is absent on this case. And in fact, we have a contrary finding in this case, that there is no detriment to the distinctive character of the marks. That was all I was going to say on ground one. So for those reasons, the finding of no damage does not follow automatically as a matter of law from the findings on unfair advantage, and the finding of no damage was entirely open to the judge and the evidence. So then on to the respondent's notice, and to be clear, to make my lord's, my lady's job easier, I'm focusing only on points 1 to 3 in the respondent's notice.
Just remind myself of what those are.
So that is the respondent's notice is in the court. Tab 3, page 33.
Yeah.
So error 1. Intention to deceive needs to be pleaded explicitly, and it wasn't. Number 2, the judge's finding of the relevant intention is inconsistent with his refusal to brand the third defendant as dishonest. And error 3, which probably logically comes first, as a matter of law, this is something we've been discussing already, as a matter of law, intention to deceive the passing off claim is not the same as intention to create a link, or indeed take unfair advantage.
Right. Can we put a line through 4 to 7?
Yes. So under this heading, first I want to look at the law insofar as relevant to this aspect of the appeal. Secondly, look at the judgment and the errors we say the judge made. And then lastly, the fresh assessment if I am right and the decision needs to be looked at afresh. So the law is largely common ground. The general test for misrepresentation is not in dispute. Insofar as the relevance of intention to deceive is concerned, I don't understand that my learned friends dispute that the passage from the House of Lords judgment in Claudius Ash represents the law, and indeed it's cited by my Lord Justice Arnold in the Glatzer and Sandoz case as a complete statement of the law.
Well, I'm not sure that's an accurate statement. It's certainly cited and it's treated as authoritative as it's binding, but I don't think I said it was a complete statement.
I may have not quite quoted it correctly, but it's not complete in the sense it doesn't deal with living dangerously and those
Exactly.
Yeah. But insofar as intention to deceive is concerned,
Why do you need to have any intention to deceive if you in fact deceive? I've never heard of Jif lemon. I don't know what it looks like. I just design a container for lemon juice which happens to look exactly like the Jif lemon one. I don't intend to deceive anybody, but the fact is that I do.
my lord, it's clear, the law is clear that you don't need an intention to deceive. That is trial law in passing off. But it's important for this case because it is the key consideration in the judge's assessment of misrepresentation. That's his starting point, and that's what, in my submission, tips the balance clearly in the face of the judgment. So our case is, as should be clear by now, there is a material difference between an intention to deceive for the purposes of passing off and an intention to create a link for the purposes of trademark infringement under section 10.3. And for that, I rely on a lower authority, but still we say persuasive, that should be persuasive for your lordships and my lady, and that's the Moroccan oil case that my learned friend took you to earlier, and that's in Authorities Bundle A, tab 8. And paragraph 32 is on page 220. And picking up in the second sentence, Miss Michaels accepted that establishing a link in the mind of the public within the meaning was not sufficient for passing off. So that's objectively speaking. And then paragraph 35 deals with subjective state of mind. Thus, so over the page on 221, thus finding whether there has been or is likely to be a misrepresentation is a global assessment. Among the factors that can be taken into account is the subjective intention of the defendant. And then picking it up 7 lines down, nonetheless, Lord Justice Kitchen distinguished an intent to take the benefit of the claimant's goodwill from an intent to live dangerously. I interpret this to mean that the latter is not to be put on the same footing as the former.
Where did Lord Justice Kitchen say that?
That was in Specsavers.
Yes, but what is the passage that he's referring to? Wait,
It must be 115, which is quoted above.
well, that seems to say the opposite. That's why I'm asking the question. If you look in the quote of
Yes.
1105, it has long been established that if it is shown that a defendant has deliberately sought to take the benefit of a claimant's goodwill for himself, the court will not be astute to say he cannot succeed in doing that which he's straining every nerve to do. So that passage seems to say the opposite.
The opposite of. Well, it's on a Judge Haycon is saying it's distinguishing an intent to take the benefit of the claimant's goodwill from an intent to live.
Oh, I see. So I misunderstood. Okay, I think I get the point. Yeah.
We're getting there. I interpret this to mean that the latter is not to be put on the same footing as the former. I think if the defendant's intent is that the name and or get-up of its product will bring to mind the claimant's product, but not lead to any false assumption on the part of the public as to any sort of trade connection, including common manufacturer or a license, then at best, from the claimant's point of view, this is neutral. So there the distinction is between an intent to bring to mind and an intent to deceive. The latter is relevant on the authorities to misrepresentation, but you can have the former without the latter. You can have intent to bring to mind without an intent to deceive.
All right, but the judge's finding in our case was an intention to take the benefit of the claimant's goodwill.
No, my lord. I disagree with that. That is not what we see in paragraphs 214 to 217.
You say to take the benefit of the mark. Is that different?
Yes, yes. To take the benefit of an illusion, a bringing to mind.
Well, but that's taking unfair advantage of the mark. That's
Yes.
the question. Bringing to mind, making the illusion, is taking unfair advantage of the mark.
Yes.
So your distinction is between taking unfair advantage of the mark and taking unfair advantage of goodwill. Is that the distinction you're making?
No. My distinction is between taking unfair advantage of the mark and a misrepresentation as to trade connection, which is what you have to show on passing off, which is that someone actually thinks these two undertakings are connected in trade. And simply bringing to mind and benefiting from that calling to mind is not sufficient.
Well, I think the question that my lord put to you was whether you accepted that taking unfair advantage of the goodwill was enough. And you said no. That's why I thought your distinction was between taking unfair advantage of the mark and taking unfair advantage of goodwill. But that's not, I think, the distinction that you are making. You're making a different distinction.
Yes, I would struggle to distinguish between taking unfair advantage of a mark and taking unfair advantage of goodwill.
Right, all right.
Both, just all that both mean is that one, there is calling to mind and there is a benefit in terms of looking on with more favour or less disfavour.
So if we were, and I appreciate you say we shouldn't, if we were to transpose the judge's findings on 10.3 into his passing off section, we could say, couldn't we, that the defendant took unfair advantage of goodwill by the calling to mind, etc., etc. Because there's no distinction, you say, between the two.
If that's all it means. So if as long as that doesn't mean taking unfair advantage of goodwill does not mean making a connection, a trade connection between the two. So in other words, if all it means is taking unfair advantage of the mark, then yes, I have to accept that as a matter as tautologist. But whatever it is, whatever the judge's finding is in 214 to 217, it is not a finding of an assumption of a trade connection, which is what is necessary for passing.
And can I ask you another question? Do you accept that goodwill is a proprietary asset?
I think I do. I'm not quite sure. Yeah, I'm struggling to see what I could dispute with that.
Yes, correct. It's an asset.
So that's what I rely on in the law, as making a distinction between intention to deceive and intention to create a link. So then I need to go to the judgment again. So it's tab 8, core bundle tab 8. And it's 231 is the start. The relevant section for the purposes of my respondent's notice. So 231.
Just while the thoughts in my mind, I
Yes.
appreciate you haven't yet made your submissions on this, so please understand. I'm just wanting to get a foreshadowing of where you're going.
Yes.
I'm not in any way trying to limit your submissions, but in view of the points you were just making, when we get to 235, which is a bit further down the line,
Yes.
the finding that the judge makes is a misrepresentation of connection between ELA and the EasyJet brand and its founder. So I appreciate you're going to criticise the reason, but at least taking at face value, the conclusion seems to be one that is legally correct, even on your analysis.
If that means something different from what he has previously found, then I'd have to accept that. But in my submission, it doesn't. So he's using that phrase, but he's transferring the findings that he's already made in the context of 10.3. So
Okay.
it's an infelicitous turn of phrase in my submission. But to go back to the actual arguments that I'm making on the respondent's notice, they come before there.
Yeah.
Because how he gets there is that he relies heavily on the third defendant's intention. That's in 231. So that's the starting point. I have found that sign 2 was deliberately created to form a link with or make an allusion to EasyJet. And the strength of that allusion was increased by the existence of the family marks. That being the case, the connection, in inverted commas, with EasyJet was intended. And it was intended to suggest that ELA's business was somehow connected with the EasyJet brand. Just as I was prepared to conclude that there was a link for the purposes of 10.3, starting from Mr. Burnside's intention to create one, I consider it right to take that intention as a strong starting point in the inquiry as to its effect for the purposes of passing off. So in my submission, it's clear from that he's talking about the same intention, the same finding of intention that he's already made. And that is a finding of intention to create a link. And that appears to be common ground between me and my learned friends.
Well, no, because Mr. Easygroup goes further. He says it wasn't just an intention to create a link, but an intention to benefit from the goodwill.
Just to if you can take out the respondent skeleton, sorry, the appellant skeleton. and go to paragraph 35. Oh, sorry, it's the reply skeleton, not the main skeleton. I apologise.
35.
35, please, yes. So this is one of the arguments that is made against me, is that we, on the respondent side, sought and refused permission to appeal the factual intention finding, capital I, capital F, in the context of 10.3 infringement. Now that term is defined in paragraph 1 of that skeleton, and it is the finding of fact that Mr. Burnside intended to create a connection with EasyJet when adopting signs 2 and 3. See judgment paragraph 232.
Yes, but the key word there is connection. He's using connection to mean more than just link.
In my submission, he's not. And that's because he's talking about the same finding of intention in paragraph 231 as he has already made in paragraphs 214 and onwards, and that is an intention to create a link.
Well, put it another way, are you saying he actually uses connection not in a legally correct sense?
That's right.
He's using it as another word for link,
Yes.
rather than consumers will think this is a licensed entity.
That's exactly what I'm saying, yes. That's the only sensible, in my submission, interpretation of this paragraph. Because otherwise, why would he talk about that intention? So then in paragraph 231, he goes on to cite the commentary in Wadlow on intention to deceive. And so that's what he thinks he's taking into account, but he's not, and that's error 3. He's taking into account an intention to create a link and conferring on it the prominence, the utility that can only be conferred on an intention to deceive, according to the authorities. That's error 3. Error 1 is, in the respondent's notice, is that if it is in an intention to deceive, it needs to be pleaded. That is a condition laid down by Claudius Ash, and it's common ground that it wasn't pleaded. So that precludes the judge from taking that into account if what he's taking into account is an intention to deceive. Now the judge excuses that condition, that requirement, by saying, well, it was firmly put to Mr. Burnside. He had a sufficient opportunity to meet it without its being pleaded. Sorry, I need to start the paragraph from the beginning. It is true that in this case, this is 232, it is true that in this case the point is not explicitly pleaded, but the deliberate adoption of the appearance of signs 2 and 3 to form a link in the mind of the public was firmly put to Mr. Burnside. That, my submission, shows what I was just saying. That's what he has in mind. It's the same finding of intention to form a link. And he had sufficient opportunity to meet it without it being pleaded. In my submission, there's no wiggle room here. That is a condition of relying on intention to deceive. And he wasn't permitted to excuse himself from that. And then finally, error 2 is the last bit of paragraph 233 on page 175, It is unnecessary to brand Mr. Burnside as dishonest for these purposes, and I do not do so, but his deliberate acts fit with the principles of this case. Intention to deceive amounts to fraud. So in order to find that Mr. Burnside had that intention, if that's what he was doing, he was required to find that he was dishonest. And in my submission, the right way to analyse what's going on here goes back to error 3, the error of law. Having not found him as dishonest, the judge's finding must be taken to be something that falls short of an intention to deceive, a fraudulent intention to deceive.
It might be said that the explanation for that is because there's no deception as to the origin of the defendant's goods or services. So it's not deception in that sense. It's not the classic form of passing off. It's the more extended form.
But if it's deception as to membership of the family, which was the claimant's case, that is still deception. It has to be, because that's the trade connection. I'm saying that Mr. Burnside was saying this is Easy Live Auction is a member of the Easy family. It is a licensee of EasyGroup. If he's saying that and intends to say that, then that is an intention to deceive. And if he's saying, no, I didn't say that, then he must be being dishonest. But the judge has found that he has stopped short of saying that. So he must have in mind that that's not actually what he was intending to say. So that's where we say the judge went wrong in 3 ways. Error 3 is an error of law, that conflating intention to deceive with intention to create a link. Error 1, the requirement to be pleaded, is also an error of law. It doesn't admit of any excuse. And error 2 is the dishonesty, lack of finding dishonesty, is an error of principle in the sense that there was a gap in logic, a lack of consistency between taking into account Mr. Burnside's intention and not finding that he was dishonest. That fatally undermines the cogency of the decision. You say, if I'm right on any of those, then the judge cannot, is precluded from taking into account that finding of intention. That was the starting point. And in 234 of the judgment, it says expressly, 5 lines down, were I to be starting from a position in which that evidence of intention did not exist, I would come to the same conclusion is perhaps not that easy, particularly in the light of the very different businesses of EasyJet and its family. But I do not need to go down that particular line of inquiry. Do not ignore that sort of evidence, but pointers the other way do not, in my view, negate the natural inference to be drawn from my finding as to Mr. Burnside's intention. So all we have in that paragraph, in the weighing up, is Mr. Burnside's intention on one side and the very different businesses on the other side. So if you take away the intention, we say the irresistible conclusion is that misrepresentation has not been made out on a fresh assessment. So for all those reasons, even if you find that ground 1...
I'm sorry to interrupt you. What are the very different businesses of EasyJet and its family on the one hand, and your clients on the other?
So
EasyJet I can see, obviously
Yeah.
different business. What about the family?
There was evidence of other licensees
Yes.
of EasyGroup.
And they're all very different?
All very different from the live auction business. Yeah, that's the clear findings peppered throughout the judgment. So, as I say, for all those reasons, even if you find that ground 1 succeeds, the judge's dismissal of the passing off claim should still be upheld because the finding of misrepresentation is fatally flawed. So then I can move on to ground 2 and the declaration of non-infringement.
Yes. I think Mr. Edinburgh did not strenuously defend his first line in the sand.
Yes, and indeed I understood that the appeal was only directed to those parts which concerned the plain words, those parts of the declaration that concern the plain words and the domain name. So yes, I was working on that basis anyway. It is common ground that the decision to grant the declaration generally, and those parts of it specifically, the form of it, involved an exercise of the judge's discretion. And in my submission, if anything, the wording of a declaration, the form of a declaration, is even more a matter of discretion than the principle of whether one should be granted in the first place. And so it follows that on this appeal, the court is policing a very wide perimeter. We'll usually defer to the trial judge if relevant considerations were taken into account. In reviewing the exercise of the judge's discretion, it's crucial to have in mind the circumstances in which the declaration for non-infringement was made. First, the judge made a partial finding of infringement. Only historic signs 2 and 3 were held to infringe. And secondly, the judge granted the conventional wide form injunction, as we've seen. So the words any sign colourably similar thereto were added, and or otherwise infringing EasyGroup's registered trademarks. So in those two circumstances, the judge was therefore rightly concerned to provide the respondents with certainty as to what they could and couldn't do, and what would be caught by the scope of the injunction. As we've seen, it was EasyGroup itself who first suggested the grant of a declaration of non-infringement to deal with those concerns. And one other important aspect of the circumstances is that EasyGroup itself had put infringement by use of the plain words, Easy Live Auction, before the trial judge by its pleaded case. And as we've seen, there were numerous examples of the use of plain words in evidence, separate from the use of signs 1 to 4. Now, turning to the ground of appeal itself, it has two parts. First, that the declaration of non-infringement was wrongly granted on the basis of a non-existent finding of fact. That is incorrect. There was a finding which supported the grant of the declarations as against the use of the plain words and the domain name, and that's in paragraph 191, where the judge talks about the circumstances under which the Easy Live Auction name was first chosen. That's in Court Bundle tab 8, page 164. So you can see, picking it up, third line down, I therefore accept that when the name was chosen and the first sign was adopted, there was no intention to choose a name or style which was close to or reflected or took advantage of a supposed association with any of Sistelios' easy claims. There was nothing in its style which would suggest any association.
Yes, but then he goes on to say the wording was in white on a blue background, the words were separated, and each of them was capitalised. So that's what he's addressing his mind to. That's not a finding about the plain words in completely different fonts.
That's a finding about the stylisation. I can take you back. So that sentence that I was just on. Therefore accept when the name was chosen and the first sign was adopted, there was no intention to choose a name or style. So there he is talking about just the name and the style.
So is it your submission that this covers putting it into Cooper Black font and with an orange background?
No, my lord. No, my lord. Of course that's not my submission. I accepted at the hearing, at the consequentials hearing, that use of Cooper Black font was not...
But the declaration that's been made covers that.
No, it doesn't. In my submission, it doesn't. I'll come on to that, but in my submission, it clearly does not in the circumstances of this case. And that is, yes, I'll come on to that. So that's the factual finding that we rely on. And given that the only that the basis for infringement under 10.3 was the intention to create the association, and that was absent in the choice of the name, that is a sufficient factual finding to cover use of the plain name. The second part of the ground of appeal is that the exercise of discretion was improper because the wording is so vague as to lead to future uncertainty to the prejudice of all concerned. To that I say, the judge had to strike a balance, and the form of declaration cannot be characterised as plainly wrong. The problems that EasyGroup purports to identify with the form of the declaration are themselves hypothetical and wholly artificial. Crucially, no issue has arisen in the real world in over 10 months since the declaration was granted, and neither party has in fact been prejudiced by it in those 10 months. The reality is that the grant of the declaration has provided certainty because the respondents have been able to carry on their plain word and domain name use, and EasyGroup has not been able to allege that that was a breach of the injunction. And we need to look at what the other options are and were at the time. EasyGroup has not even attempted to address the problems caused by not granting the declaration for non-infringement in this form. Its position is that the respondent should only have a declaration of non-infringement in relation to sign 4 and possibly sign 1. This position is entirely consistent with its overall litigation strategy, which is to create maximum uncertainty for the respondents in the hope that they'll hand over their trademarks and unregistered rights so they can be added to the portfolio. As the judge said, if the declaration was not granted, this particular declaration, the injunction would give EasyGroup a weapon for unnecessary harassment. Entirely reasonably and correctly, the judge was not willing to give EasyGroup that weapon. And before I go into a bit more detail, I want to deal, or at least try and deal up front with some suggestions from the bench before the short adjournment. Firstly, my Lord Justice Arnold's suggestion about the wording. It is open, in my submission, to this court to titivate the wording, but the limitation proposed by my Lord Justice Arnold would not be sufficient, in my submission, to protect the respondents and provide certainty, because it would only cover the exact uses that had been made before the last day of trial. There have been and will be uses of the same type that we've seen that my learned friend has taken you to in the supplementary bundle, but they will be new uses, so will not have the certainty of being covered by the declaration. And again, in my submission, you don't need to go there because, as I say, no problem has arisen in relation to the form of wording arrived at by the judge with the assistance of the parties. And the second suggestion from my Lord Justice Lewison, in my submission, it's not necessary or appropriate to remit the question to the judge. The plain words were before the court as a matter of the infringement case, and he has granted an appropriate form of declaration as a balancing exercise, having granted a wide form of injunction. In other words, I'm not confident that the wording can be improved. It's not caused a problem, not likely to cause a problem. We don't need to go any further. So in terms of detailed submissions, that the circumstances under which the declaration was granted, I think I can take that quite quickly given my learned friend has said that. Second, the law relevant to this ground. Third, the factual finding as the basis. Fourth, the improper exercise of discretion. And fifth, looking at the alternative. So the circumstances under which the declaration was granted. I think what my learned friend didn't take you to was the prayer and the particulars of claim, in terms of what was showing the scope of the claimant's case. If you go to the core bundle, tab 40, page 297. This is the prayer for an injunction, and it's an injunction to restrain the defendants, and then skipping over to subparagraph A, from using the sign easy, live, auction, or any sign colourably similar thereto. So it's not an injunction to restrain the use of signs 1 to 4, or any sign colourably similar thereto. It is an injunction to prevent use of the plain words. And given the time, I don't think it's necessary for me to take you again to the examples of use of plain words that my learned friend took you to have one of the supplementary bundle. But it's common ground based on that there were uses of the plain words which are not uses of signs 1 to 4. They were before the court at the time. So this was not a hypothetical problem for the judge to solve. And then my learned friend took you to the relevant sections of the transcript. He took you in particular to the section of the transcript where the judge expressly recognised that EasyGroup was not successful in a claim for infringement by use of plain words. So they didn't have the finding of infringement there, and they would be issuer stopped from running an identical claim again. And so, as I say, that's the judge recognising that it was before the court. And my learned friend's suggestion was, well, that's enough for us to have that acknowledgement. As I said at the time, it's my submission now, if that's the case, that should be reflected in a declaration of non-infringement to give certainty. Yes, there was just one other bit. So if I can take you to the core bundle, tab 9, page 217. And it's little page 134, lines 11 to 12. So my learned friend is raising expressly the problem of precision. So we say your declaration would be bad for want of precision. Judge, that is what concerns me. Mr. Akins, I see your point about the domain name, but I'm reminded to make it clear that the use of words domain is not an infringement for the avoidance of doubt. Then we go on and have a debate about the words to be used in the declaration. My point about that is that the concern about precision was raised before the judge. There were submissions on both sides as to the wording used, and the judge reached his decision accordingly. So he took into account all relevant matters. And that shows that the judge exercised his discretion entirely properly, and his decision was both not plainly wrong and moreover the correct one. I don't think, on reflection, I need to discuss any aspect of the law, but because I think it's all common ground. In my submission, it's all common ground here. There is one point on the burden of proof, because my learned friend did mention it in his speech. And it's correct, wouldn't dispute, that if I was the claimant in this action and I was seeking a declaration of non-infringement as the primary cause of action, then I would bear the burden of proof. But that's not this case. We were defendants, and the circumstances under which the question of the declaration emerged were unusual. So we had the finding of partial infringement, and we had the wide form of injunction, and so it only came into the equation as a result of those things. So it's not.
Whoever had the burden of proof, it was satisfied by the judge's findings of fact.
Yes, exactly. Yeah, it was the issue of infringement was before the court.
Yeah.
So it had to be decided one way or the other. So that's the only point that I would make on the law. At the findings of fact, I have taken your lordship's, your ladyship to already. That's the finding in paragraph 191, and of course related to that, I pronounce what the judge said at the time about recognising that the EasyGroup was not successful in their claim for infringement by use of the words, and that they were issue stopped for that. So then we come on to what is said to be the vague wording which leads to future uncertainty to the prejudice of all concerned. The problems that are identified, excuse me, are as follows. I think there are three. The first is fonts. So it's probably helpful if we have the actual order before us. So it's the core bundle, tab 11, page, well, the declaration starts in paragraph 2 on page 249, and the actual signs are set out in paragraph 3, and it's C and D that we're concerned with. And there are three problems that my learned friend purports to identify. The first is fonts, and he sets out a number of different fonts in paragraphs 45 and 46 of his skeleton. The first point is that this is all entirely hypothetical because the respondents have never actually used any of these fonts. EasyGroup has not pointed to any actual use by the respondents of any other font that has created a problem of interpretation, either previously or before.
The declaration immunises you.
But this is the judge had to strike a balancing exercise. This court has to strike a balancing exercise if it wants to look at it afresh. And I would accept that perhaps no solution is perfect in these circumstances. But what the judge has to do, in light of the wide form of injunction that was granted, was to provide certainty to all the parties and the defendants in particular.
Where does this idea of balance comes from?
Well, perhaps I need to take you to Specsavers in that case, because that's the only other case that I've found where a similar situation arose. So there was a debate there on the scope of the injunction, and
The declarations are declarations of right. So you've got to identify a right before you declare what the right is. And is there a balance to be struck there, or do you just have to identify what the right is before you declare it?
well, there certainly needs to be a basis for the grant of the declaration. So I've shown that there is that basis in this case. The plain words were before the court.
No, I follow, but if A says, I've got a right, and B says, no, you don't, the court's got to adjudicate between A and B and decide what the right is. It's not striking a balance by coming to some sort of compromise between the two positions.
Yes, I mean I would accept that, but the situation is complicated, where you have an injunction which is of indeterminate scope.
Yeah.
And so then the task for the court, in my submission, and you see that from the Specsavers case as well, is to say, well, where there has been partial findings of infringement, and there's an injunction in wide form, so of indeterminate scope, what can I do to protect to give
But that's precisely the point. The point of the declaration, for the very reason you've just given, is to tell your clients what they can do in the future without contravening the injunction.
Yes.
And this one tells you that they can use any font, which would include Cooper Black.
No, in my submission it doesn't, because it can't be stylised. It can't
Why
be
is Cooper
stylised.
Black font stylised, but if you use Garamond, that's non-stylised?
My lord, it's not. It is stylised because that was precisely the subject of these proceedings. So the use of Cooper Black font, it was.
Sorry, I'm sorry, that's not my question. My question is this. The only word you've got in the declaration is non-stylised.
Yes.
You say Cooper Black font is stylised.
Yes.
Right. My question is, why is that stylised, but a different font, such as Garamond, is not stylised?
Because the stuff. Well, it probably would be. I don't know. I confess I don't know Gamma which font that is.
Right. So this is useless to your clients then.
Well, it's useless
Because on this basis, nobody's got any idea what this declaration covers and what it doesn't.
That's in my submissions. That is simply not the case, because what it is intended to cover is use of easy live auction, the words, in a way that is not different from its surroundings.
So
That's
if
what's
you
meant by this.
if you put out all your promotional literature in Cooper Black, that would be all right.
No, because Cooper Black was precisely the subject of these proceedings.
Well, it's not in the
There
declaration,
was a lot of argument
but it's
about
not in the declaration.
No, because it's covered by non-stylised. Oh, sorry, it's precluded. It's excluded by non-stylised. The idea that the use of Cooper Black font by the defendants would be use of the plain words in non-stylised form, in my submission, in the context of this case, is simply not supportable.
What, yes.
Because it would be
What is the
styled.
difference between a stylised form and a non-stylised form? I thought when you were explaining to the judge, you said it's got to be in the same font as all the rest of the
Yes.
text. So that's why I asked you, if you put out all your promotional material in Cooper Black, so that the use of the words easy live auction or in exactly the same font as the rest of a full-page document, would that be stylised or not stylised?
Yes, because it's use of Cooper Black font, and that is
Well, that-
clearly discussed in the context of this case.
Well, that's what I can't get out of the words of the declaration.
In my submission, with the factual matrix of this case, which is the background for interpretation of this declaration, that is tolerably clear to all parties concerned. So this is an artificial problem.
Yeah.
Yeah. Which paragraph? 31. Yeah. So I'm reminded, paragraph 31 of the judgment, that the judge talks about the fact that Cooper Black font is a essential component, characteristic of EasyGroup's branding.
To be sure, exactly. But your own point is that your clients have never used it. And the
Yes,
question is, what can they do going forward?
right. They certainly cannot use Cooper Black font, because that would be stylized. Whether other text around it is in Cooper Black font or not. And I acknowledge that expressly in the course of argument.
I think we've exhausted that one. What was the next one?
There are two others, colour and goods and services. So again, colour, EasyGroup has not pointed to any actual use by the respondents of any colour that has created a problem of interpretation. Whether use of any particular colour would be covered, in my submission, can't be answered in the abstract. Because
So plain orange text is all fine as far as you're concerned.
no, it depends on the context. for any declaration, you're going to have to look at the facts and work out where it is. Nothing is going to be perfect unless there's nothing at all. But that is not acceptable because that leaves the defendants in a totally impossible position
Well,
with
that's
this
the whole
particular
point,
claim.
isn't it? It's in your client's interest as much as anybody else's to have a declaration where everybody knows what it means.
Yes, and in my submission, that is what we have because there has been no problem with it. All these problems are hypothetical and artificial.
Yeah.
And you need to compare that, my lords, my lady, to the proposal on the other side, which is no declaration at all. So, of course, Orange is likely to be problematic because it's an essential component of the claimant's get-up. Lastly, goods and services. It's correct there's no specificity in relation to goods or services, but that, in my submission, is not a problem for the following reasons. It is fanciful to suggest that the respondents are going to start providing airline services, which is what the claimant implausibly
Property
suggests.
auctions. Easy Property is one of the businesses that's relied on.
Yeah, but property auctions were not. It wasn't held that if we went into it, but the problem was the type of auction that we were conducting.
If your clients expanded into property auctions, which is a realistic prospect, then there's possibility of conflict.
In my submission, no, not based on the findings in the judgment. Absolutely not. The findings were that the auction business, there was no problem with the auction.
Well, I think the way that Mr. Edenbrook puts it is a very wide way. I mean, it wouldn't make a lot of business sense to use the words easy live auction to provide airline services. I mean, the
Well,
words
no,
themselves tell you that what you're doing is some sort of auction.
Precisely.
I suppose you could auction airline tickets maybe, but
There are two other points on goods and services. The first is that EasyGroup didn't seek to limit the declaration to specific goods and services at the hearing itself, and that includes the declaration that it proposed in relation to sign 4. So, on its logic, we should be entitled to use sign 4 in relation to airline services. And lastly, the injunction was not qualified by reference to specific services. So, it must follow from EasyGroup's argument that that is also problematic. Surely, use of sign 2 in relation to goods or services which are completely different, for example, parts for specialist oil drilling machinery, should not be restrained, because that would not be an infringement. But that's not covered. That's not the way that injunctions are granted. And so the declaration in my submission needs to be treated with the same level of reality.
yeah.
So that's why we say this is not a problem, because it's based in the real world. It hasn't created any problem for the parties or prejudice to the parties. And as I say, that needs to be contrasted with the alternative, which is no declaration, at least no declaration in relation to C and D at all. That would leave our historic uses in jeopardy, as well as future uses at the same time. EasyGroup is not seeking an injunction restraining use of the plain words, even though that's what it sought in its prayer for relief at the time. It just wants the uncertainty of the wide form injunction to stay hanging over it and the absence of the declaration. That, in my submission, the judge was right. That would give the EasyGroup a weapon for unnecessary harassment. And in my submission, that is exactly what it wants, and that is not something that the court should give it.
Yeah. Thank you very much, Mr. Wickens. Yes, Ms. Wickenden.
Thank you, my lords, my lady. I plan to go back in order as we have done, going to ground one and then dealing with the respondents and then going on to ground two. I think in large part I can probably be fairly brief, as a lot of the points I was going to make have already come from the bench in one form or another. I will just revisit them where I think a particular point is pertinent or anything new that's come up that my learned friend has addressed. But if you feel I am covering well ground at any point, then of course I'm happy to move on. Going to the first point made in relation to our ground one, that principally the whole basis of this is wrong in law, as findings on 10.3 are not transferable to findings of goodwill, misrepresentation and damage. I think my learned friend has, just, well, in to a large extent, over-abstracted our case in what we were actually trying to say here. It is not simply that we are trying to do some sort of sleight of hand by transferring the paragraphs in relation to a link and unfair advantage into damage. We are relying on the actual findings of misrepresentation in the context of passing off, where it is quite clear that the correct findings we say were made. So in large part, debates over the different in nature of a link compared to a misrepresentation that could cause damage falls away. I mean, I just think you drew my learned friend to it, but I think it does just bear emphasising the sections of the judgment where the judge made his findings specifically on misrepresentation. In the judgment, we have 8-page
Paragraph 229
I
onwards.
should pick it up as, yes, this is 229, I think it's up to 231, which is...
231.
Yes, quickly going over the page and 174, and in my submission, this is where the narrative really should start. My learned friend took you to the discussions in link first, then try and suggest, well, these later findings on misrepresentation, even though squarely within a section on misrepresentation, are in fact instead merely findings in relation to link. As has already been flagged, you can see quite clearly in the context of misrepresentation, the judge referring to paragraph 231, that what was found and to be intended was that the business was somehow connected with the EasyGroup brand, and then refers back to that supporting his conclusion on link. He then says it also supports passing off. And then, of course, over the page on 235, we have the clear finding that signs 2 and 3 amount to relevant misrepresentation of connection between ELA and the EasyGroup brand and its family, and it would mislead a relevant portion of the average consumers. Now, it seems to be said for the first time today that the judge did not actually mean the connection in the right legal way in paragraph 235. And that would be a strange thing to assume, given that we have a legal judgment. But I think it's also worth just pulling up in that context that it's the connection that has always been pleaded in the context of passing off. It's not simply that the judge has drawn this word connection out of nowhere. The relevant bits of the pleading are reproduced in our reply skeleton, which I'll take you to for convenience at tab 7, paragraph 20, on page 88.
Where were you?
So I'm in the appellant's reply skeleton, core bundle tab 7, page 88.
Yeah.
And this was put in the context of the pleading on intention, which I will come back to, but I just wanted to flag, just to clarify how the party not case was actually pleaded at paragraph 49. Still very alternatively, by reason of the matters exhausted, and in particular owing to the goodwill in each of the relative marks in the private reputation, the acts of the defendants are likely to leave a substantial members of the public in the United Kingdom, given that the defendants' services are those of or connected with the claimant, or a member of the EasyGroup's brand of business, or otherwise the subject of some commercial arrangement. So connection was one way that it was put. A member of the EasyGroup brand of businesses was another way that it was put. But the way that it was found was on the basis of connection, and that is, of course, the foundation, we say, for the finding of damage, and it's important to have that in mind. And a lot of my learned friends' submissions seem to amount to effectively a challenge on the type of misrepresentation, saying, well, there needed to be a different kind of misrepresentation or potential damage found. And on that basis, he said that what was found in terms of that there was a benefit that wasn't paid for is not enough. But we say, well, there's clearly the findings of misrepresentation. We have the paragraph 216 that we've already gone through. I won't take it again, and it's not been paid for. And our case simply is that you put that together, passing off. We don't put our case on the basis that there's been blurring, tarnishment, etc., which in large part is the case that my learned friend spent some time meeting. We put our case on a much more straightforward basis. I don't think I need to go into any more detail on that. My learned friend has already covered the types of damage and misrepresentation. I've just a few further points of principle that were mentioned in relation to ground one. One is that my learned friend said that there is a distinction between the remedy of damages as opposed to damage as an element of cause of action. Those are different in nature and had to be treated differently. In our submission, there's no distinction there, only where in the case and crucially when that is considered. And certainly in terms of the pleadings, there's been no pleading taken that there is any distinction on damage and passing off as opposed to damages generally. And actually, it's worth just pulling up the pleading in relation to damage in the context of passing off. It's tab 55, page 313. And paragraph 33 deals with the paragraph from the particular claim as introduced in the skeleton I've just shown you. And paragraph 33 simply says the allegation of misrepresentation in paragraph 49 is denied for the same reasons as set out above in relation to the claim for registered trademark infringement. The claimant's claim for passing off has nothing to do with its claim for registered trademark infringement. So actually, there's no, if there's a point that my learned friend says that there's some key distinction in denying damage as a principle as part of the tort of passing off, and there's actually no pleaded defence to that. It's only denied over the page in paragraph 39, where there's the general denial of the claimant will suffer or is likely to suffer loss. The next point I wanted to move on to was that made in relation to change of economic behaviour, and I think the point being made, as much as I understand it, is the distinction was drawn between the change of behaviour of the claimant's customers as opposed to the defendant's customers. And I think what was being put is that damage for passing off had to be a change of the claimant's customers. And effectively what we're talking about in terms of change of economic behaviour with customers is when you're talking about the claimant's customers, if something's changed there, then you're talking about a direct loss of sales. And we know from authorities who've already reviewed that the damage elements of passing off are not limited to a direct loss of sales. So we must be able to look at the defendant's customers, and we say that's exactly what the judge did in this case, considered the benefit taken without any...
Well, that comes back to the same point, doesn't it? Whether obtaining a benefit from your exploitation of someone else's goodwill without their consent counts as damage. If it does, then you might well measure it by reference to the benefit you have received or what you would have paid for permission to do what you've been doing.
Yes, and exactly that, and also that when you consider potential change of defendants' customers, we also consider the possible likely future use or use that hasn't been in fact demonstrated, for example, by loss of sales or loss of specific licenses. Now, what was put and where I believe this point was really going to was a submission that if this was our case, then we needed concrete evidence of a loss of potential licensing opportunity. Final country was taken to, I won't go back to it, I think we can just make the point that there's no overriding principle made in that case that we would need evidence of such kind. There simply was in that case, and it was taken into consideration. What we also have in this case is extensive evidence that the claimant is a licensing business. There were other licensees referred to, there was evidence from licensees. It could not have been more clear to everyone involved that the claimant made its business by licensing its brands. In such situation, it is in my submission a strong and even I can't remember quite the way that I think it may be an irresistible inference that damage would be made. And in my submission, there is enough there for the judge to make that finding, and certainly for this court to make that inference as well. It was not something that we needed specifics for. That would be a matter for a quantum trial. I'm not sure if that point is directly related to the next one. I think it may have been that the paragraph 216. Sorry, I'm actually looking at the 237, where the judge actually used the wording, so it says tab 8, page 176, the wording that we've considered already, where the judge says, I'm afraid I do not understand that logic. And it's the first time today there's been any suggestion that that was actually a finding on the evidence. It's certainly always been understood by us that there was no dispute, that the judge simply did not follow that there was a logic of a head of damage under that basis. And in my submission, you just have it's too much of a strain to try and infer from the earlier section of the paragraph that we fail on the evidence, especially given we have very extensive parts of the judgment elsewhere where the judge was quite detailed in telling us how we failed on the evidence. I think if we had failed on the evidence here, there's no reason to think that the judge would not have made that express. There's a bit of dovetailing with the respondent's notice, but that was all I intended to say in relation to damage, unless there's anything further I can insist on background. So I think to start on the misrepresentation, it would be worth coming back to what we said at the front about supply skeleton, which is at tab 7, page 62. the start of our paragraph 3 on the front page, it is important to note that the intention finding is only ever said to be one of the main factors in the multifactorial assessment of a representation, sorry, of misrepresentation. He certainly did not say that intention was the only basis.
Sorry, where are you?
So our reply skeletons, tab 7 of the core bundle, paragraph 3 on page 82. So really, before we, my learned friend can seek to persuade you on anything, he needs to demonstrate that there would have been a different finding if the intention was taken out. And my submission has not even got that far because he's not addressed you on the extent to which it has been so significant that he says if you remove that, the balance must tip in his favour, and certainly that doesn't not meet the high standard which he acknowledges he needs to meet, that this the multifactorial assessment was not one which was open to him.
I don't think we know what the judge would have decided without intention, do we? What he says in 234 is whether, were I to be starting from a position in which evidence of intention did not exist, I would come to the same conclusion. It's perhaps not that easy. So he doesn't say that he would or he wouldn't. He says he doesn't really know.
Well, I don't think I'd accept that he says he wouldn't really know. He says it perhaps wouldn't be quite so easy, which in my submission is an implication that the same result would have been made, but it wouldn't have been as straightforward as him for him to get there. Certainly that's the stronger reference than the alternative, which is that he only relied upon intention. He certainly had well in mind that it was just one factor that he needed to consider, and one that, while it's not a requirement, which I think would be well trodden, it can be of evidential relevance. And I think that then leads me nicely onto, well, what sort of intention would it need to be? My learned leader has already addressed you on the authorities, particularly Glaxo and Sandoz, that there is certainly no principle that intention to deceive is the only kind of intention that can ever be relevant in a passing off case. It's very clear that living dangerously is recognised as something that can be taken into consideration either for or against the defendant. It simply cannot be said that it is sort of fraud or bust, intention to deceive, or the judge has to close their mind to any evidence that might otherwise assist him as to answering the ultimate question of, well, objectively speaking, how will this sign operate on the minds of consumers? And the judge rightly also took into account the fact that in this case we have a defendant who has been deliberately found to have intended to certainly take unfair advantage, create a link and create a connection. And those are all matters which are open to him evidentially to take.
Can I just ask you about that? Because, I mean, one of the points taken against you is the pleading point, to which you say, well, to some extent there was a pleading, and clearly whether it was. But just, it's my fault, I probably should have asked Mr. Akins this, but I can ask you since you're on the topic. When Mr. Burnside was cross-examined about his intentions, I take it there was no objection that he was being cross-examined on a point that hadn't been pleaded?
Absolutely not, and he was cross-examined quite widely, and I plan to take you to that after to dealing with the pleading point, because it's certainly not common ground, as my learned friend said, that it's not pleaded. And actually we don't accept that it was right for the judge to say in the strong terms he did that it wasn't pleaded. I set out in our reply skeleton again, we're going back at tab 7, back to the section that we looked at a minute ago. page 88, the various bits of pleading. And as is often the case when you're running trademark infringement and passing off cases together, particulars relied upon in relation to trademark infringement are then relied upon in relation to passing off. And there was a deliberate, an allegation of deliberate acts of infringement in the context of unfair advantage. That's subparagraph 48.3. It's set out at page 88. And then that, if you
So can I just unpick that submission for a moment? I fully understand that you're relying upon the emboldened words. Benefit is unfair because it arises from the defendant's deliberate acts of infringement. But do I understand your submission is that in context that must be an allegation of an intention to benefit from the association?
Yes, I think that's the primary submission there, that the very same factual matters, namely the deliberate intent to benefit and the defendant's deliberate acts, was relied upon both for trademark infringement and passing off, based on the usual wording in the premises, relying on the above, etc. That's sort of the primary submission, and certainly even if you're not with me on that, it cannot be said that deliberate intention in the context of it being unfair and seeking to benefit was not squarely put at all. It was very clearly put in the context of unfair advantage, and indeed when it was dealt with by the defendants, they simply denied the entirety of passing off for the same reasons as
Well, you
trademark.
quoted a bit of the transcript, so paragraph 23, in which this is put to Mr. Burnside, and that is reflected, I think, in the judge's, as it were, primary findings of fact at paragraphs 192 to 195. So those are the facts he found. When he came to 10.3 and or passing off, he was answering slightly different legal questions. So it's not entirely surprising that in transposing those primary findings of fact into a different legal framework, he used slightly different words.
Well, precisely, and I think it's worth bearing in mind that there's only a certain extent to which you can repeat cross-examination questions in different wording to a witness and expect a different answer. We do have the section of the transcript in the supplementary bundle, which I think it's worth going to. It's the supplementary bundle tab 9, page 122, starting at main page number 378, and at line 13.
Sorry, where are you?
Sorry,
Supplementary?
Supplementary bundle tab 9, main page 378. And from lines 13, we're talking about the changes.
Yes, that's the bit you've quoted.
Yes, I think I wanted to just go on a little bit further, just to highlight the fact that it was put in broad terms in a number of different ways. And at line 20,
yeah,
I say you've done deliberately to get closer. No, absolutely incorrect. And then it was put specifically to form sort of link and call to mind. Easy branding, absolutely incorrect. And then again put on the basis of confusion. No, you're incorrect. So it was put very broadly all the different levels of intention. We are certainly, in my submission, well covered, both in terms of the pleading and in examination, in this matter being properly before
yes.
the witness. And then there's not pursuing other elements. So I think that's probably everything. I mean, given that we are not alleging an intention to deceive per se, that there can't be any basis for saying it's inconsistent that the judge hasn't found him to be dishonest, because we have that lower threshold in relation to the relevant intention. I think that's everything I was planning to say on the respondent's notice, unless there's anything more I can assist with. I just have some very short points in relation to ground 2. The mere fact that we've had such a range of submissions on what the declaration actually means, in my submission really gets to the crux of the issue on how it's formulated. It was also said that we should take aid from the transcript to try and understand what is covered. Obviously, that's not the basis of having a declaration of infringement. If something isn't clearer than the actual judgment that we have, then it's not serving any useful purpose. And I just wanted to make a point of policy here. My learned friend didn't, I think, actually turn up the Specsavers case, but she said it's the only other case where a declaration has arisen on this basis. I think it is. Let me just, I don't think we need to take you to it. Certainly there's nothing that we can see that is helpful guidance, principle, and there's nothing from my learned friends skeleton stating that that is something clear that we should follow. But what we do know is that these are that is the only case that either of us has been able to find where there has been a declaration of non-infringement following trial, where there's not been a specific plea for relief of the form of a declaration of non-infringement. We've got a taste from just today and from the hearing already potential minefield that can arise when you're trying to, as my leader said, pull a declaration of non-infringement from sort of the ashes of a judgment. It would be an incredibly dangerous precedent in our submission for a declaration of this form to stand, given that the lack of clarity and the likelihood that we'll end up in more confusion than it actually manages to resolve. It seems to be an obvious floodgates issue of every unsuccessful or partially successful defendant seeking to try and argue in the hearing for the first time that there should be a declaration of non-infringement. Everyone has coped so far. We of course have the law of res judicata, which whilst it's not an ideal clear scenario in every situation, it does exist. It protects in situations not only of a clear issue estoppel, but also the Henderson and Henderson type estoppel, which is what we have here, and which I would just emphasise again, the distinction between there being an issue which is even perhaps before the court but not properly decided upon, compared to one where there is a clear finding of fact. It's not that there is a vacuum there, that does not protect defendants. And of course we have, I'm not sure that the sort of the balancing exercise my learned friend proposes is right in law in any event, but of course it must be taken in mind when you have an injunction, you're considering balancing that there is a proven wrongdoer, and that is what we have here. The focus has been on sort of protecting the defendants, but of course the defendants have been, in this case, found.
Well, you have someone who's partially a wrongdoer and partially a right doer.
Well,
that's the balance that Mr. Akins relies on. He says, well, you accuse me of all these different kinds of infringement. You've managed to prove some, but not the rest. So I'm not completely the villain of the piece here.
In my submission, it's not about who is and is not the villain. It's the fact that some infringement has been found out is enough that we say that's the key matter of reality that needs to be taken into account, not what the claimant may or may not do with any particular order. And of course, it's not at all unlikely that in the lead up to this appeal, the defendants have not changed their use as to create issues. The fact that there's not been any issue sort of policing them up to date really is not one of any significance at all. It would be very surprising indeed if any defendant, given the issues before the court today, has pushed the line, as it were. And unless there's anything either from beside me that I can assist you with, that's everything.
Thank you very much, Ms Whittington. Mr Akins, I don't think there are new points raised on your respondent's notice.
With your lordship's, your ladyship's permission, there was just one point.
Yes, all right.
To pick up on the respondent's notice, because my learned friend did say in terms that EasyGroup was not alleging intention to deceive, which of course is the focus of our respondent's notice. That wasn't put in cross-examination. That is what the authorities say is relevant, intention to deceive, and those are the authorities that were cited by the judge. That is what the judge thought he was taking into account. Of course, these authorities weren't cited at the time because this wasn't raised as an argument at the time by EasyGroup. If they're not even alleging intention to deceive, then the whole basis of the judge's consideration of intention in the context of passing off is destroyed. It follows that his finding of misrepresentation cannot stand and it should be dismissed based on a fresh assessment.
Thank you very much. Well, thank you all for your interesting arguments. We will reserve our decision. You will get a written draft judgment in the usual way, which will be limited in its distribution to those on the distribution list who've been notified to the court. Otherwise, it will be under strict embargo until it's handed down. The receipt of the draft judgment will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgment, you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short submissions in writing before the hand down, and we will make the appropriate order that we think fit. The hand down will be remote, done electronically, so there is no need for any attendance. And please don't expect a judgment as a Christmas present. Thank you very much.